Welcome to the webinar series on recent developments in copyright law in South Africa. This series is a collaboration between the Mandela Institute at Wits in Johannesburg and the program on information justice and intellectual property at the Washington College of Law at the American University in Washington. I am Sania Samtani, Senior Researcher at the Mandela Institute. So really what this webinar series aims to do is to demystify the recent developments in copyright law. The first webinar is titled International Copyright Trade Policy and South Africa. Just to introduce to you all, Professor Flynn, who teaches courses on the intersection of intellectual property, trade law, and human rights. He's also the director of the program on information justice and intellectual property. Professor Flynn chairs the Global Expert Network on Copyright User Rights and is also a founding member of the Global Congress on Intellectual Property and the Public Interest. A little known fact about Professor Flynn is that he was clerk to Chief Justice Arthur Chaskalson at the South African Constitutional Court, as well as Judge Raymond Fisher at the U.S. Court of Appeals for the Ninth Circuit. With that, I will hand over to Professor Flynn to begin your presentation.
Good. Thank you so much, Sania, and to the Mandela Institute for hosting this series. It's an interesting kind of starting place for this series to start with the international law aspects and especially the trade law disputes. And I say it's kind of interesting because as I'll present to you, hopefully rather forcefully, there is no trade law dispute here. It's really one of those issues that has very little legal substance, but it does have a lot of political substance. And I'm actually going to start with the political economy and discuss a little bit of the history of trade threats against South Africa over its adoption of what we call the international flexibilities in the international system, the policy space that is given to countries to design their own IP according to their own economic and social policy interests. It also provides us an opportunity to kind of look at some of the main political critiques around the bill, and especially this kind of complaint about adopting a US-style fair use exception within the limitations and exceptions in copyright has become the hottest issue in South Africa, as if that is really the most radical thing the bill does. And I'm going to conclude, if I have time, by arguing that it's not the most radical thing the bill does, that there's much more radical provisions that I also think are justified. So every so often, seems like every 6 months or so, there's some kind of article in the Sunday Times or some other newspaper saying that the proposal to adopt fair use within the South Africa copyright bill is drawing US and even European trade threats. And that's kind of true. The different kinds of distribution platforms, the record labels, the publishing companies have been lobbying the United States Trade Representative and the equivalent institutions within the EU to threaten South Africa with some kind of trade sanctions, usually the denial of preferential treatment under their trade laws, the removal of special and differential treatment that accords South Africa preferential tariffs under the US and EU trade regimes. That these large content industries have been lobbying the US and EU to threaten to remove those benefits because of the consideration of the adoption of a fair use right within the Copyright Amendment Bill. And so that part is true. Those industries have been lobbying those officials, and we also know that those officials have been having various kinds of dialogues with the South Africa government. We don't have evidence that the US and EU has literally threatened to revoke trade sanctions. We do know that in the US, for instance, there was a pretty big hearing in 2020 around South Africa preferences under the AGOA program, which is the African Growth and Opportunity Act, which accords special and differential trade tariffs to African countries, including South Africa. So there was a hearing. It was instigated by, the International Intellectual Property Alliance, which mainly represents kind of Hollywood content industry. is often allied to the pharmaceutical industry as well. And that organization, the IAPA, has a long history of complaints and successfully lobbying the United States Trade Representative to exert various kinds of pressure, specifically on South Africa. So you may recall as well the last time threats by the United States against South African intellectual property policy was front page news. And that was at the time of the AIDS crisis around the turn of the century. And the issue there was the 1994 WTO agreement, World Trade Organization agreement on trade-related aspects of intellectual property rights, included provisions actually clarifying flexibilities for countries to use various mechanisms to overcome high prices on patented goods. And so that agreement said that you could issue what's called a compulsory license. You could force a patent holder to license another company in order to allow that other company to provide cheaper drugs. Or you could, through a technical intellectual property rule called exhaustion, the idea that the intellectual property owner's right exhaust cease to exist after the first sale of that product. And then it's up to local law to say in what market. So if you use an international exhaustion rule, that means that the local buyer in South Africa, for instance, could purchase that same good in another market where that same good was put on the market at a lower price. So in this case, back in those days, AIDS drugs, and South Africa, by some measure, had the highest percentage of AIDS patients, people that were HIV positive in the entire world. But the medicines to treat that condition were being sold at a lower price in Australia than in South Africa, which is interesting to think about. Australia is a much more wealthy country than South Africa, and it had a much lower incidence of AIDS. So there's a much more acute need in South Africa, and yet the prices to serve that need were higher than in a high-income country. And so South Africa sought to use the least aggressive of the two tools. It decided to not use the compulsory licensing tool, but it instead authorized what we call the parallel importation, gray market importation of the same branded product, not generic product, branded product from other markets where it was sold more cheaply. And that authorization within the South African Medicines Act brought the criticism and lobbying of the IIPA, the institution that I just talked about, and the pharmaceutical industry, which I believe are also members of IIPA. And they convinced the then Clinton administration to use the Mbeki-Gore Commission, those were the two vice presidents at that time, to send messages from the United States to South Africa that its consideration of the use of this tool may lead to trade sanctions by the United States, including withdrawing special and differential trade tariff agreements, just like is being threatened now. So there's a very similar political effort that happened in those two moments. It's some of the exact same actors. It's a similar effort by South Africa to take advantage of its ability to craft its laws according to its own interests within the confines of international law. I would say in each case, almost every scholar of the really legal issues didn't see a legal issue there. But nonetheless, the threats were real. The response in that time was a social mobilization. It literally launched an organization called Health Gap which were AIDS activists from America first, and then that organized globally to help support South African activists, the Treatment Action Campaign, etc., in the US, and to create a partnership between the Treatment Action Campaign and global AIDS activists to apply pressure in both places. And ultimately, those threats were removed. World Trade Organization passed or adopted the Doha Declaration on Trips and Health, which made it very clear that you could not threaten other countries for using flexibilities on access to medicines. And South Africa has never been threatened by the US on an issue involving AIDS medications since. The prices being charged in South Africa at the time were between 10 and 12,000 US dollars a year for a cocktail of drugs that could be received at that point from Indian pharmaceuticals at about $300. And the reason South Africa often faces especially high prices is because it has the highest income inequality in the world. And so if you have a very, very small number of very, very rich people, and you have a monopoly on that market, you will make more money selling a very small number of units at a very high price than you will serving the entire market at the price the whole market can afford. So South Africa will always face ridiculously high prices from the perspective of the median income earner, vis-a-vis countries with more equal distribution of income, even if, like Australia, that the median or average income is much higher. Prices in South Africa tend to be as high as prices in the US or UK, which have about 10 times as much GDP per capita than South Africa. I showed the pricing of AIDS drugs, but actually prices in the book markets are very similar in South Africa. If you compare prices for the same exact book between India and South Africa, prices are often as much as 10 times higher in South Africa if you enforce the copyright on that textbook, you enforce the patent on that medicine, and you don't have any legal rules that control the excessive pricing of those items, then as I've told you, the economic logic will enforce a very high pricing within the South Africa market compared to other markets. And so here I can kind of come out as my accent suggests as an American legal academic. And American legal academics come out of a particular legal tradition that was created between the 1920s and the 1950s. That was a critique of the use of law to restrain policy, and specifically to make way for the reforms that created the administrative state under FDR, for instance, and coming up into the post-World War II economy. We shifted from a much more laissez-faire system to a system with a much greater social democratic way of structuring our economy. It's the birth of the administrative state. It's the birth of the regulatory state. It's the birth of our welfare system. It's the birth of our social security system. It's the birth of our public health care system. And at that moment, in order to resist the legal conservatives who are arguing all of that is unconstitutional, and against that, the dominant argument that wins the day has at its core this insight from the both legal scholar and economist from Yale University at the time, Robert Hale, is that the distinction between the state and the market collapses within law. The market value of a property, the price, is merely a measure of the strength of the bargaining power of the person who owns the one or renders the other under the particular legal rights with which the law endows him. It is the law that determines price. If your medicines in the 1990s are priced so high that there's actually literally no way South Africa could have purchased all the drugs it needed to treat the people within the country. There was an AIDS incidence of over 40% It would literally cost all of your GDP to treat just the people in the country that had HIV. But that price comes from the legal rules that South Africa at the time was enforcing. It was choosing to not use a compulsory license and choosing to not use parallel importation, in part because it was being pressured. And then eventually it chose differently. And it has since issued compulsory licenses. And now there's relatively universal treatment of people with HIV in South Africa. We changed the legal rules, which changed the price and allowed us to scale up treatment. Now, that's the political context. So what is South Africa trying to change in the South African Copyright Amendment Bill? And I'm just going to focus on the limitations and exceptions here because that's the argument that we hear being made, that there's something in the Copyright Amendment Bill that is creating unfair exceptions to the rights of, it's often stated authors, but it's not authors so much making the argument. It tends to be publishers and music labels. And it's important to keep casting your eye towards those two entities because those are global monopolies. There's only 3 or 4 major publishing houses in the world. Almost all of the local South African publishing subsidiaries are owned by multinational publishing corporations. And the same is true for the music industry. There's only 3 or 4 big labels in the world. And all the local labels tend to be subsidiaries of the multinational labels. So it's already a monopolized sector. The distribution layer is monopolized. So what is the CAB trying to do around this issue? One of the things it actually is doing is regulating on the side of artists and requiring equitable remuneration, of extending the rights for artists to control works they didn't have before, to require that contracts with those subsidiaries with that distribution layer expire after 25 years and need to be renewed, so prompt a new negotiation. These are all tools in Robert Hale's sense that tries to raise the bargaining power of artists vis-a-vis the distribution entities. So how do you create more bargaining power on the side of the buyers vis-a-vis those same distribution monopolies that are giving low prices to the creators, but then are flipping around and charging the buyers much higher prices? So the way you do that is you expand the limitations and exceptions within your copyright law, if that is your purpose. And I understand not everyone agrees with that purpose, but I think the legislature certainly agrees with that purpose. The South Africa Copyright Amendment Bill looks around the world and it finds what I call the most open general exception. So let me define those terms. So every copyright law gives exclusive rights to whoever owns that entity to exclude others from the copying and selling of that material. And then there's always a series of exceptions which say that the copyright owner's right to exclude other people from using the good doesn't reach these other activities. So for instance, in the main international law on this topic, the Berne Convention says that every copyright law has to have an exception, at least for quotation, even if the quote is wrong or malicious, factually incorrect. All of these are part of your free expression right? It would be unconstitutional, according to many courts, to have a copyright law that doesn't have that ability to use, at least for that purpose. Copyright law, the rights, the exclusive rights, call them rights, don't trump all the other fundamental rights. And I think all of us would agree that copyright law with no exceptions would violate those fundamental rights. So then the question is, how do you construct those exceptions? the distinction isn't between civil law and common law. The distinction can be around the terminology that I will call open and closed, and general and specific. An open exception is an exception that applies to all the different elements of the exclusive right. So the exclusive right potentially covers any kind of use. So that term fair use that you've heard battered around, the reason that term fair use is critical is actually the word use, not the word fair. Every exception actually has a fairness test. It's not always called fair. There's always some kind of protection of the rights owner to make sure that the user isn't going too far. And that's all fair means in the US context. And really that term fair occurs in many civil law countries as well. Like lots of countries in the civil law tradition call it fair practice instead of fair use. Well, it's the same thing. But it's important that it says something like use or practice, because if you only say reproduction, then that's just one of the many exclusive rights that copyright has. But your law presently says fair dealing. So people that say, oh, there's a big difference between fair dealing and fair use, that's literally not true. The terms fair dealing and fair use mean exactly the same thing. A dealing is any use. A dealing means all of the different rights protected by copyright. So at least at that moment, there's no real distinction between what South Africa has now and what it's proposing to move to. It may or may not change the term from dealing to use, and it won't matter. It will have no significance to change those terms. Both actually the present South African fair dealing exception and what it proposes to have in the future, and what I have on the screen here, which is the US clause, apply to all works by all users. It's not an exception just for a movie or just for a literary work or just for an educational work or whatever. It's all different works. And there's no restriction on the kind of user. You don't have to be a student or a teacher or a library or anything else. So in that respect, we call it a general open exception. Now the change is the inclusion of the opening clause with respect to purposes. So both the US law and the South African proposal use the words such as, and then it lists some purposes, but because of the such as, the purposes are now open. You can use it for other purposes that are somehow like those purposes. It's not a closed list. So that's the open versus closed as respect to purposes. And that's the change that's being proposed. Now, why is that important? You already have an open exception under fair dealing. So many other countries, sometimes civil law countries, only have lists of specific exceptions. They don't have a general exception that's open to all the different kinds of uses of all the different kinds of works. So you're already in the Anglo-American tradition now. By including such as, it allows the purposes to change over time. So the US fair use exception hasn't been amended since 1976. Indeed, there wasn't even video cassette recorders with a record button on them in 1976, much less DVRs or cloud storage or email or all these internet search, text and data mining research. All of these things technically make copies of works in various ways, but have held to be fair under fair use if challenged, and often just exist, have never been litigated. The idea that you need litigation under fair use is also factually incorrect. What fair use gives is an argument. It allows you to say, this particular use isn't specifically mentioned in the bill, but because of the openness of fair use, I think it's fair. Look through the factors. It doesn't compete with you in any market. When I create internet search that literally copies the entire internet and puts it into a database and then spits out identifiers of where you can find those things. It's not copying the relevant material in any way that competes with the owner, so I shouldn't have to license it. So that's the benefit. South Africa is not the only country considering opening its exceptions. If you combine kind of all the different categories that we know of, there's at least 18 countries today that either already statutorily or interpretively opened their exceptions in a similar way. Usually you include some kind of such as terminology, as South Africa is considering. Some of our recent work looks at actually research exceptions and maps how open research exceptions on the world. Here, the green countries are the ones with open research exceptions. We find that all countries, as they amend their laws, tend to adopt more open exceptions, but you can see there's a gap between developing countries and developed countries. High-income countries tend to have more open exceptions than low-income countries, which begs a question of why. As I said, I don't think the legal issues are very serious here. So can you have more open exceptions under the international corpus? Both international human rights law and your own constitution requires all state entities to promote the Bill of Rights as it's amending and interpreting legislation. Denise Nicholson originally created the great Wits site that has lots of information about the copyright bill, including the background on the trade arguments. But the trade argument is basically this, that international copyright law, the Berne Convention, 1886, has a provision on exceptions that says that exceptions must be in certain special cases. And there's a decision by the World Trade Organization that says we have to give a lot of meaning to that phrase certain, that parties must have legal certainty. There's critiques of that decision. It's not clear whether it's really authoritative. Certainly the scholars don't love it. But even if you go along with it, there's nothing in that decision that says you can't have fair use and fair dealing. And if you look at the latest Marrakesh Treaty on the facilitation of access for visually impaired people, you find that fair dealing and fair use laws are explicitly incorporated within the history of the three-step test and the way we've applied it in the future. So it seems pretty clear to me that adopting an open general exception complies with international law. But sure, there can be a little issue there. One could create a logical footnote to say that there's something in dispute. But why I think that this is really a non-issue is that countries like the United States and Europe cannot unilaterally adjudicate that on their own and cannot sanction a country by denying them preferential treatment under a special and differential treatment clause just because they feel it violates that rule. They have to litigate it first, and they're not doing that. There will be no litigation filed by the United States against South Africa for anything in the Copyright Amendment Bill because most of it's based on concepts that exist in US law. And the GSP enabling clause, which authorizes and regulates the administration of special and differential treatment, says it can't be reciprocal. You can't deny treatment of one country that you don't deny others for, or that you don't do yourself, or as an exchange of favors between two countries. So the international law really bans this type of use. And I don't think the most radical thing in the law is certainly the fair use clause. What's certainly the most innovative, I think, if not radical concept within the South African Act, which is to combine a competition law standard, an excessive pricing standard, with its limitation and exception, and say that if the textbooks are priced too high, then you're going to have a broader fair use type standard to use even a whole textbook within an educational market. And it can't be for a commercial use, but we're not going to deny our children textbooks because the monopolies are pricing them too high. And I think that's an interesting standard and is probably the most innovative one. And I think it complies with the international rubric as well.
Thanks so much, Sean. That was really fascinating.